Appeals Division 1 is now in session.
Thank you. Be seated. We are here in regard to 1 CA CV170033, and I do not want to butcher these names, so you might, if we mispronounce them, please let us know early on so we don't do it throughout. But I want to say Rajiv Singh versus Rakesh Malhotra.
Rakesh Malhotra.
Malhotra, thank you. For everybody's information, we are going to be audio and video recording these, so it does matter how we pronounce them. And barring any unforeseen problems with that process, you'll be able to critique yourself on YouTube in a couple of weeks. Each side is going to be allowed their usual 20 minutes. We would ask that you respect the 20-minute time period. The timer located on the podium will let you know how much time you have left. And for the appellant, I want to advise that if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know, and we will try not to take all your time up. However, ultimately, the reserving of rebuttal time is your responsibility. We have reviewed the briefs and conferenced the case this morning. We are well aware of the facts and issues attendant to it. In this particular case, not that you straightening out some facts for us might not be really helpful, but we have reviewed the matter this morning. Please keep that in mind when you calculate how you want to spend your time in addressing the court this morning. Counsel, when each of you come to the podium, I would ask that you state your name and who you represent. And with that, appellant's counsel, it's your podium.
Your Honors, may it please the Court, Al Arpad for the plaintiff and appellant Rajiv Singh. I would like to reserve 3 or 4 minutes. There appear from the briefs to actually be some disagreements about what the issues are and what the facts actually were, what happened below, and so I would like to reserve 3 to 4 minutes for rebuttal, unless the questioning precludes that.
Mr. Arpad, in that connection, can I clarify just exactly what's before us? You have raised issues regarding the use of the hospital settlement proceeds.
Yes, Your Honor.
So that's one class of assertions here. And then there are assertions related to this contract that was assigned or however it was transferred.
Yes, Your Honor.
It appears to me that regarding the hospital settlement proceeds, you have briefed on appeal why your conversion claim should have been allowed to proceed, but you haven't really briefed as to that factual bundle. You have not briefed the fiduciary obligations and unjust enrichment claims. You have unjust enrichment and fiduciary obligations with regard to the contract. Have I got that right?
All three should be reversed. We primarily focused on it as a conversion claim because a conversion claim is the legal claim that would have taken this out of the equitable area that became a problem later on. Right. But the standards would be essentially the same for all of those. And you're absolutely correct. Those are the claims. And the second claim is sort of split up into 2 parts because one claim against the hospital contract or about the hospital contract was also dismissed at summary judgment, and we don't think it should have been. And again, that's a common law claim which the judge would not have been able to reverse the result on if we won in front of the jury, we did.
I think maybe your allusion indicates this, but I have a little confusion as to how we review a trial judge's ruling that rejects an appellate or an advisory jury's verdict. It seems like it's not exactly the same as with a legal claim when a judge grants a new trial with regard to a regular jury's verdict.
I think it is quite different. Essentially, in an equitable claim, my understanding is that it's as if it was a bench trial. So you review it as you would with a bench trial.
So that the existence of the jury is just an anomaly, basically. And I don't mean to be rude toward the process, if you will, or disrespectful toward the process. But the jury's there, they're giving an opinion, and the court can either take it or reject it, and no harm, no foul?
That's largely true under modern practice. Back when advisory juries were more common, there's language in old cases about how the judge should only appoint an advisory jury if the judge wants to hear what they have to say, and then shouldn't imprudently disregard it. But the fact is, it's a bench trial at that point, and the judge has the ability to, I don't think there's an actual rule against the judge reversing it, but there is a rule that says the judge has to explain why she's reversing it, and so that comes into our argument about alternative grounds.
But, and it's in the context, though, that the judgment ultimately has to be sustained by the evidence.
The judgment has to be sustained by the evidence, but I think our argument there, well, there are two reasons why you should overturn the judge's decision to reverse a judgment that was entered and then enter a new judgment that provided the opposite outcome. One is because the judge had improperly split off these other claims which were relevant, and we think the result might have been quite different if they'd all been tried together.
Granted summary judgment.
Granted summary judgment, yes. But the second reason is we've basically attacked her legal reasoning. When a judge reverses from a bench trial after entering judgment, the judge is supposed to explain why, and the judge did in fact explain why in this case, and we've taken her at her word. We think she provided a sufficient explanation for the reasoning that she gave, but we just think she's wrong. And so we think she's wrong on how she analyzed the legal issue. It's not that there couldn't be a different. The bulk of the testimony in the trial was from Dr. Malhotra, and so different fact finders could have come to different conclusions about whether he was credible or not. We recognize that. But the judge didn't apply the business judgment rule correctly. That's our argument against the third component of it, the judgment that actually came from the judge on the trial. Does that answer your question?
Yes.
Okay. So let me start quickly with the settlement with the Banner Hospital lawsuit. This is relatively straightforward. It's a summary judgment issue, and it's wrong on basic summary judgment grounds. First of all, the moving party had the burden. Dr. Malhotra was the moving party. His burden was to establish at least the basic factual premise of his motion before the burden shifted to us to show that, no, that isn't what the facts were. The facts were different. The only thing he really pointed to was a few pages of extremely confusing and evasive testimony in his own deposition, which frankly didn't establish anything. When you look at the transcript of the oral argument, the judge really has very little idea what's going on, is questioning the lawyers pretty intensively about it. But you can see from that transcript where the judge is essentially putting the entire burden on the plaintiff, on the non-moving party, to establish the facts.
Well, what about this National Bank versus Thurston case that we issued about 10 years ago that seemed to say that all that has to be done is to point out the other side doesn't have facts to support its claim?
No, I think it does not. I don't think it says that, Your Honor. I think what it says, along with Orm's School, is that just a conclusory assertion that there's no evidence isn't good enough. You've got to, you don't have to conclusively prove that the other side is wrong and you're right as the moving party, but you have to at least give a plausible explanation of why you're right so that the other party knows what to argue against. You can't just say the other side has no evidence and then somebody in a 15-page motion is supposed to put on their entire trial case in order to show that they've got evidence on this, every conceivable thing that could be out there. So that's the basic burden shifting idea. They didn't even meet their basic burden at summary judgment. The second problem, and this one is pretty obvious, is that there was in fact an expert opinion saying that this split wasn't fair. And it was pretty simple and it was pretty straightforward, but it was based on court records that were available to everybody. And the expert, I mean, really, it was almost more of a Rule 1006 summary of some documents that were from the other case, more so than any kind of complicated, controversial opinion. He was just saying, no, look at the documents. It wasn't the company's claims that had been limited and dismissed. It was Malhotra's claims that had largely been limited and dismissed. This was an unreasonable division of the proceeds. That was there, and the trial court never addressed it. And frankly, again, I think if you look at the oral argument, you can see there's several pages where the trial court has some words for the attorneys for presenting such confusing motions, And I think the trial court just missed it because she never mentioned it. I mean, I don't know why she wouldn't have said, I'm disregarding this, and why she's disregarding it if she had any reason to do it. But at any rate, it wasn't argued, it wasn't excluded, and so it's there. It's in the record, and it's a basis for not granting summary judgment. It shows that there is a factual dispute as to the appropriate division of those lawsuit proceeds. And again, I just want to emphasize the Beacon Theaters case that we had cited. If you start overturning the summary judgment motion so that legal issues should have gone to the jury, you then have a very different factual scenario on the basic issue of motive, which the trial court ultimately found to be dispositive. And so you can't have the trial court resolving on an equitable basis issues that should have gone to the jury under any of these claims if they're common issues. Now, there are even more common issues when you get to the second summary judgment issue, and that is the tortious interference claim. The tortious interference claim was one of several claims that had huge factual overlap, and although the law of them is different, in reality the contested issues were extremely similar. It was thrown out on the ground.
Overlapping with the fiduciary obligation and unjust enrichment claims pertaining to the hospital contract.
The hospital contract. That's exactly right, Your Honor. The factual background is the same, so all of those factual issues about who to believe and what's actually happening are the same for those claims.
Press, just for a moment, you're not suggesting there's a bunch of overlap between the hospital settlement aspect of the case and the hospital contract?
There is much less. Those are different claims about different pots of money. But there is an overlap because what the trial court ultimately
You're alleging general self-dealing, I think. Is that fair to say?
Yes. The trial court ultimately resolved this based on her assessment of is he looting the company, is he not looting the company. And the hospital settlement part goes straight to that issue. It's substantial evidence that he is, in fact, looting the company. And so,
Counsel, if we were to go with that and say there was looting of the company that took place, does that require us just to wash what's taken place and send it back to start over? Or is there a way of dividing the baby here? Is it possible to do that, or is this just a start from scratch?
It's extremely difficult because of the way this played out. It's extremely difficult to split the baby because if you send back the summary judgment claims, those have obviously got to be tried. And what we're saying is because of Beacon Theaters and frankly just because of general fairness, the claims ought to be tried together. And I don't think the trial becomes any longer or more difficult just because you add in the breach of fiduciary duty claim along with the tortious interference claim. You're going to try the exact same facts.
Are you saying as a matter of fairness, or are you saying as a matter of practicality? Is it just basic fairness that they have to be tried over, or are you saying it just doesn't make any sense not to try them over?
I would agree with all of those things, but I'm saying the legal reasons why you ought to do it that way are fairness. I mean, adding things to a trial doesn't make it more practical. I'm saying it won't make it very much less practical, and it is the fair thing to do, and it is the necessary thing to do under Beacon Theaters. Does that make sense as an answer? Sure. Okay. On the tortious interference claim, just very quickly, briefing sufficiency is an issue that was raised in the answering brief. We tried to point out very, very clearly exactly what was said in the opening brief. Really wasn't addressed in the answering brief. And so you've got to look at it and see, is the briefing sufficient to preserve this argument?
I thought the reason that the judge threw out the interference with the contract claim was because of this notion that MALHOTRA couldn't interfere with his own contract, and he was the corporation.
Yes, and that was briefed on both sides as essentially being the same issue as the conflict of interest issue that would arise in a fiduciary context. Now, they're not legally the same thing, but as a practical matter, they're pretty similar. A conflict of interest equals exposure. That's the idea reduced to its most basic terms. He doesn't get off the hook for being the sole shareholder under either a breach of fiduciary duty theory or under a tortious interference theory if he has this conflict of interest, if his interests diverge from the interests of the corporation, if he's acting in his own interest, in this case pretty much 100%, rather than for the corporation's interest.
The problem I have is I'm having trouble understanding how Malhotra could benefit from what I think is not proper. I mean, if he truly was treating the corporation as his own plaything, then he would be violating fiduciary duties, I would think.
Yes, the two are very, very parallel. He's violating fiduciary duties, and he's also considered, under the case that was in fact cited by Malhotra's side, that if his duties conflict because he's acting for himself rather than for the company, then the tortious interference claim should have survived too.
So to defeat one, you defeat the other.
Yes, as a practical matter. And the only exception to that would be if this statutory business judgment rule comes into play. Now, this was never really briefed in any detail by the parties throughout, but
doesn't that rule just say if you don't have a conflict of interest, we're going to defer to business judgments?
Traditionally, that has been the rule. And again, it's an odd procedural thing because my predecessor trial counsel was the one who was saying, well, there is this statutory business judgment rule which arguably narrows it. There's no case law, so we don't know how much it narrows it. So, and she says it multiple times throughout the course of the case. So I only brought these two claims where I thought he was 100% acting for himself and 0% acting on behalf of the company. He gave $0 to the company. He gave 100% of the dollars to himself. Those are the only ones that I'm going to even talk about because no matter how you interpret this statutory business judgment rule, that should be outside of it. That was her position throughout, and so I tried to present that as faithfully as I could to you. That conflict, then, you can look at it a couple of different ways when you're looking at the protection of the business judgment rule. You can either say that takes it outside the business judgment rule because the business judgment rule is premised on acting on behalf of the corporation, or you can say, well, it's at least strong evidence that he wasn't acting in the corporation's best interest. Again, two slightly different legal analyses, but it's the same theory. This was the fact that he took all the money is in itself the most overwhelming piece of evidence in the case that he wasn't acting in the best interest of the corporation.
Saying you reach the same end.
You reach the same end. That's correct, Your Honor. And that is what we think the trial court really overlooked when she focused almost exclusively. She said initially, in her ruling, she said initially, I was really convinced that that was a big deal. But then I went back and I looked at all the things Dr. Malhotra said about what his reasoning was, and I'm just convinced that there isn't a showing here that he was acting in bad faith. She doesn't use the term subjective or objective, but I think she's applying a subjective standard there, saying unless somebody comes into court and testifies to spite, to ill will, to this and that, I'm just not going to overturn the business judgment rule.
Well, didn't he say in his deposition somewhere that he gave away the hospital contract because it's the only way he could benefit from it? I mean, something to that?
There were lots and lots of different things that were said. There were things that
I don't think you take one piece out of it and make that dispositive, but that's in there, isn't it?
Yeah, there's evidence from a jury could have decided that piece of it either way. I will acknowledge that. And the judge, who was actually sitting as the finder of fact above the jury in this case because of the equitable aspect of it, could have found that piece of it either way. But the judge, in her ruling, said, that's really the only thing I looked at. I'm going to ignore the elephant in the room. I've decided not to really think of it in terms of the huge amount of money that's changing hands and the corporation being left with nothing.
The only thing she looked at was what?
I'm sorry?
The only thing that she looked at was what?
It's a relatively long minute entry, but the minute entry I think is fairly clear. She says initially I looked at the fact that he took it all for himself and I thought that was a big deal. But then I looked at the fact that his testimony is, no, I had these other motives and the company was falling apart and therefore I'm going to find that he wasn't acting in bad faith. And we think she was looking really at the wrong thing and excluding the most important piece of evidence. Then you have the exclusion of evidence issue, which has been brief. I won't use up my time on it unless you have questions. And then you have the fact that, again, the evidence from the other claims wasn't brought in and tried together. And when you look at all of that, she's really not looking at the whole picture when she makes that decision. I'll reserve my 2 minutes, if I may.
Thanks, counsel.
Good morning. Carrie Francis on behalf of the defendant, appellee Rakesh Malhotra. And I do want to clarify a few things. The bench trial and how we review the bench trial has a specific legal standard versus compared to the summary judgment claim. So I'd like to start with the bench trial and the court's entry of judgment on the two claims that were tried to her. First, neither party requested findings of fact pursuant to Rule 52A. No findings of facts, no conclusions of law. And the trial court made none. She issued a reasoned opinion, but she did not make specific findings of facts or conclusions of law.
But initially?
After the trial, the bench trial, on the fiduciary duty claim and on the unjust enrichment claim that were tried to the court as a bench trial.
But weren't there two separate judgments?
The final judgment I'm talking about.
Okay. Because there was one before that.
That was, yes, and after reviewing, a motion to review and amend that bench trial decision, she issued her final judgment.
But so there were no findings of fact or conclusions of law for the first judgment either?
For either.
Okay. And what is the status of the advisory jury's conclusions or findings?
I agree with counsel that it has no effect.
And it doesn't even affect our evaluation of the trial judge's ultimate determination?
No. The advisory jury is just there to guide the judge in making the decisions for the bench trial. So the standard under Rule 52A, when there are no finding of facts and that judgment is up on review, is that this court should presume that the trial court found every fact necessary to support its judgment on those two claims that were tried to the court, and that this court should sustain those presumptive findings of the trial court if they're justified by any reasonable construction of the evidence.
Right, but then if we're talking about a legal question, which is how I would have to view the assertion about, I mean, I know this is the summary judgment thing, but I'm having a lot of trouble with the idea that MALHOTRA could not interfere with his own contract when the contract belonged to the corporation. I realize it's summary judgment, but
because the principles that surround whether or not a conflict existed are based upon facts that the trial judge determined. And so the trial judge determined that there was not a conflict of interest, that the interests of Saguaro, the medical practice, were aligned with Dr. MALHOTRA's decision making. So those facts based whether or not there was a legal issue and the application of that rule. So at trial,
but I don't see how, even if MALHOTRA is perceived as having pursued the corporate interest, that doesn't make them identical for purposes of the tort of interfering with contract. They're still a separate person, even separate from the corporation, even if the decisions he's making do not conflict with the corporate interest.
They are separate interests. I agree with that, Your Honor. But the interests were aligned because in this case, the trial evidence and the evidence that was submitted at summary judgment by Dr. MALHOTRA, as he was the sole decision maker, he was the sole person operating this company, was that Saguaro couldn't perform that contract. There had been events leading up to the transfer of the contract with Havasu that led Dr. MALHOTRA to conclude.
Right, but I'm still, I mean, I understand your argument that the decisions he made were consistent with the corporate interest, but that doesn't make the parties identical, or doesn't identify him with the corporation. He still is required to act with regard to the corporation as if he's not the same thing.
I understand.
And so formally and legally, I don't understand her conclusion that that tort couldn't proceed because MALHOTRA was the corporation.
Well, as to the specific tortious interference claim, that claim was brought on summary judgment. It showed that Dr. MALHOTRA was on both sides of the transaction, so there was no third-party interference. And that's what the court focused on, is that in order to pursue that type of claim, you have to have third-party interference. And there is case law that speaks to this issue, this exception to the tortious interference claim, and we cite that in our brief.
Well, I'm familiar with it, for example, in wrongful termination cases where the boss fires somebody for a wrong reason. The somebody sues the company because it acted through the boss. And then they sue the boss for interfering with the contract between the company and the plaintiff, and we say, well, because of respondeat superior, the boss is not a third party to this transaction. But here, by definition, Malhotra was not the corporation. He was required to treat the corporation as a separate person. And so you couldn't legally identify them as far as I can tell, even if he was seen as acting in pursuant of the corporate interests. I'm just stuck on that, I guess.
And I think the court focused on the third-party interference because he was involved on both sides of the transaction. He wasn't causing anybody not to perform or interfering with a contract with a third party because he's
the third party. He's interfering with the contract between the corporation and the hospital. That's the theory.
But that contract wasn't interfered with because it was performed.
Well, that's a different basis. That's a whole other thing. But the assertion is it not, that he interfered with that contract between the corporation and the hospital?
And I think the court's ruling was that there was no interference.
I thought the ruling was that he wasn't a third party.
The trial court's ruling exactly was that Dr. Malhotra, as a matter of law, did not cause a third party not to perform in contract with another, nor did he cause a third party not to enter into or continue a business relation with another. That's the language.
He caused the corporation not to have its contract anymore.
I understand, but the contract couldn't be performed by Saguaro. And I think part of the issue, too, at summary judgment on this particular claim was there was this showing of no third-party interference, and then, in response, this exact claim was not addressed at all in the responsive briefing.
Corporation and the guy that's supposed to be acting for my benefit takes away my only asset. I would say my contract's been interfered with.
But here, when the contract can't be performed, and the only one that would perform it is Dr. Malhotra on both sides, he's the physician that's going to provide the services under the contract. He's not taking the contract away from anyone. It stays with himself. There is no interference. The contract continued to be performed because he's the one that would have the legal obligation under the contract as the sole shareholder. But I think another issue with this claim was it wasn't addressed in response to the summary judgment motion. In the footnote in dealing with this particular claim, the court says that the plaintiff did not address this legal argument at all. It was waived. So what we're hearing now on appeal, we're hearing for the first time. These issues were not presented to the trial court, and they've been waived because it wasn't a part of the briefing below. I think another fundamental issue here is what obligation Dr. Malhotra owed to the corporation, to Saguaro. Throughout the appellate brief, Mr. Singh puts forth this theory of a trust fund doctrine, or at the time of insolvency, what duties were owed to creditors. This theory of liability was not dealt with below. It was not disclosed below. This was raised when there was discussions about advisory jury instructions. The theory was then withdrawn by Mr. Singh, and after the trial court indicated it would reject this because this lawsuit isn't brought by a creditor. So those fiduciary duties that are set forth in the A.R. Teeters case that Mr. Singh talks about repeatedly in his brief, that there's certain fiduciary obligations owed to creditors at the time of insolvency, those aren't applicable here because Mr. Singh isn't in this case in the capacity of a creditor. He bought these claims from Saguaro's bankrupt estate. So he stands in the shoes of Saguaro, not in the shoes of a creditor. And I think that's confusing throughout the brief because the actual fiduciary obligation that the court dealt with was the duties owed by Dr. Malhotra to Saguaro. And she focused on, was there a misappropriation of assets by Dr. Malhotra from the corporation? And so after the bench trial, the court accepted Dr. Malhotra's position that there was no misappropriation of the asset. In this case, after the bench trial, we're talking about the transfer of the Havasu contract. That was a particular asset at issue in the bench trial, because Dr. Malhotra had presented evidence that that contract had no value to Saguaro. Saguaro could not perform, and
But it had value to somebody.
it was actually a liability to Saguaro, because if they couldn't perform, they had certain obligations under that contract. There was a loan that was part of the contract. There were obligations for staffing. So had Dr. Malhotra not done something with that contract on behalf of Saguaro, he would have been in breach. He was in a terrible position. He had a contract that he obtained, and he had no physicians to service the contract. He couldn't recruit physicians under the Saguaro name because Saguaro had been tainted by this dispute with Banner Health, one of the largest corporations, healthcare providers in the state. And so he tried to find an administrator. He tried to find physicians. He tried to help Saguaro service that contract, but he couldn't. And so those obligations Saguaro was going to be in breach of. It was going to owe money to Havasu because Havasu was loaning Saguaro money to recruit, to perform under the contract, to find an administrator. And Saguaro could not do that.
And did he benefit from its assignation?
From the transfer?
Yeah.
Dr. Malhotra actually benefited less from the transfer
Then what?
if it had stayed with Saguaro. He was 100% owner of Saguaro, so all the profits from that contract would have come to him. In the arrangement that existed, because he couldn't find an administrator to service the contract under Saguaro, he had to give up a 49% interest. The entity that actually serviced the contract was called Polaris. Dr. Malhotra only owned a 51% interest in that entity.
So he only owned controlling interest in that company, not
100%. So the transfer actually financially harmed him. He did provide services as a medical physician and was paid for those services under the contract, but that would have happened on either scenario. So the actual profits of the company, he weakened his position through the transfer. He didn't benefit from it as if Saguaro could have retained it. So these were the reasons that the trial court accepted and found that his testimony was credible, that he had not breached his obligations, that he had not unjustly taken something from Saguaro. And because the standard under a bench trial, when there are no findings of fact, is that any reasonable construction of the evidence should support upholding the judgment, that evidence should, in this case, on this appeal, support upholding the trial court's judgments on the issues for the bench trial. Moving to the issues for the summary judgment motion, we've talked about the dismissal of the tortious interference claim. Mainly that was dismissed because it was not dealt with or answered at all in the briefing on that issue, as noted by the court. As to the fiduciary duty claim that was dismissed at summary judgment, that concerned the asset of the Banner settlement proceeds distribution. In prior questioning, you asked whether or not the issues were interrelated. We believe they're entirely separate. The issues of the Banner settlement, that litigation proceeds, that happened in February of 2010. The transfer of the Havasu contract that was the subject of the bench trial happened in May of 2008. So you're talking 2 years apart, completely different events.
the same precipitating conduct.
He is the same sole owner, but and I don't believe it is the same precipitating conduct. When the transfer was made, I've explained all the factual issues that were going on that caused Dr. Malhotra to reasonably believe that he needed to do something to perform under that contract, those obligations. Otherwise, Saguaro was going to be in a worse position. With the settlement proceeds, the evidence submitted at summary judgment was there was a portion of the settlement proceeds that were distributed to Saguaro. Saguaro initiated the litigation against Banner. It took a loan to pay for legal fees and expert witness fees. When the settlement from the lawsuit happened, a portion of the money from the settlement was allocated to repay those debts of Saguaro. So this is not a situation where there's looting going on. There is a thoughtful process. At summary judgment, Dr. Malhotra submitted evidence to the trial court that he got the advice of counsel and that he made the distribution, the separation of the funds on that basis. There was an amount of money, a substantial amount of money that went to Saguaro. It was just used to pay legal fees and other debt obligations that Saguaro had incurred.
Had Saguaro had incurred?
Yes.
No portion of that was paid in the course of his divorce?
No. And the plaintiffs dismissed any claims they had related to how legal fees were paid between personal monies and business monies. So the evidence at summary judgment was that Saguaro had initiated the lawsuit. Dr. Malhotra joined the lawsuit later. So when the case was first filed, it was just Saguaro that was incurring fees, paying experts, and acting on its own behalf in pursuing that lawsuit. It was later on that Dr. Malhotra joined that suit after he was terminated by Banner Health to assert claims relative to his termination. So the initial phase of the litigation, Saguaro was acting alone as a plaintiff and incurred costs and expenses. So when the distribution happened, the settlement happened with Banner, as Dr. Malhotra submitted in his affidavit and deposition testimony in support of the summary judgment motion, an allocation was made to Saguaro to repay those amounts. And the judge relied upon that evidence. And there was no evidence to refute that that allocation was somehow improper.
But defendant got money, right?
Dr. Malhotra?
Yes.
Yes. From the settlement.
So it didn't all go to lawyers and paying off the loan.
The money that went to Saguaro was used to repay the loan. Dr. Malhotra did get a portion of the settlement proceeds allocated to him because he had separate and independent claims that had survived summary judgment. At the time of settlement, he had ongoing valid claims.
Was there an order dividing those funds at the time they were paid as to how they would be divided and who they would be paid to, or was it just paid over to Saguaro?
I'm not sure I understand the question. Did the trial court order?
A lot of times with a settlement, you're settling as to all the claimants, right?
Correct.
And so you will break out each claimant by the amount of money that they are paid from the total proceeds of the settlement.
Correct.
In this case, was the money paid over to Saguaro and then Saguaro divided it, or was the money paid individually to Saguaro and individually to Malhotra?
The money was separated.
In the division at the time it was paid?
Yes. Correct, Your Honor.
Well, it was separated by Dr. Malhotra, was it not?
It was separated during the settlement process by the entity that was paying, by Banner. So the settlement was created, if my memory serves me correct, because it's been a while now. So my memory is that a certain amount was paid directly to Saguaro and a certain amount was paid directly to the law firm on behalf of Dr. Malhotra to his trust fund to pay for his personal claims.
So if Singh's complaint alleged that Dr. Malhotra allocated the proceeds from the settlement to himself, that was erroneous.
That is inaccurate. And the judge looked at the evidence on summary judgment, and there was nothing to controvert that. There was no one that came in and said that allocation was improper. Counsel did refer to an expert affidavit that was submitted. That expert affidavit is one substantive sentence. It says more than 10% should have gone to Saguaro. It's a completely conclusory opinion. It contains no facts, and it was not given weight by the trial court. So the
Go ahead.
So the trial court properly entered judgment on the fiduciary duty claim about the distribution of the Banner settlement proceeds.
Counsel, if we're looking for a portion of the record that supports the position that the settlement proceeds from Banner were divided by Banner so that no one had any choice but to take them the way they were distributed in the settlement, where do we find that in the record?
It's not in the record. We would have to supplement the record. That was not something that was submitted.
Thank you.
It wasn't an issue. The judge took Dr. Malhotra's testimony as to the division and relied upon his testimony in ruling on summary judgment. And so it's Dr. Malhotra's testimony that establishes how the money was divided.
And he said that it was divided by the payor?
He wasn't that specific in the testimony. That was a specific question that you asked for evidence on. The evidence at summary judgment was that this was how it was divided and what it was used for. So there was an allocation to Saguaro. My time is up.
It is. Thank you, counsel.
Thank you.
Counsel, you may have seen a little bit of shock and high interest there. Can you address any of that?
I will try to, Your Honor, in the very limited time that I have left. Starting where we ended up with the division of the settlement, that was the point of the first argument that I made, is you can't tell from the record what the heck happened to that settlement. And therefore, there was no basis to even go forward with that summary judgment motion. It was divided by the terms of the settlement. There's nothing in the record anywhere that's going to say that that came from Banner and Banner dictated it. Part of it went to pay off a life insurance loan. That's undisputed.
But you're okay with that part?
Well, it went to pay off it went to pay off Dr. Malhotra's pension loan. If you know anything about pension loans, only Dr. Malhotra, the company can't go into Dr. Malhotra's pension loan and take out a loan. A lot of frustration in that oral argument about those issues. But the fact is, the basic predicate facts were not established in the summary judgment motion. And we then presented an expert saying, no, this wasn't a proper allocation. Please take a look at that deposition testimony, and I think you'll find it's not conclusive with that issue. Profits from Saguaro. That's not established anywhere in the record because it wasn't decided what they would have been if he'd done things differently. But I'll just throw one factor out there for you. One of the benefits that Dr. Malhotra got by switching the companies was that he didn't have to pay off Saguaro's creditors, and then that went into bankruptcy. So
that was a question I had. I mean, if the money had been paid into Saguaro, one might typically think that a business that is winding down, I think we all understand what that means, would use the money that was available to them for the purposes of satisfying creditors' claims so that then you weren't piercing corporate veils and chasing ex-shareholders.
And that is exactly why, for both the legal tortious interference theory and for the breach of fiduciary duty theory, there's not an identity of Dr. Malhotra and his entity, is because that's exactly the situation that the company was in. And counsel referred to the trust fund doctrine. Again, I think we were very clear. We're not bringing a case on the trust fund doctrine. That was simply a factor that went into why Dr. Malhotra can't claim that his interests are identical to the corporation. That's how it was used. If you look at that section of the transcript where we're arguing jury instructions that Dr. Malhotra's counsel referred you to, you'll see it's very clear. The judge understood and Mr. Singh's counsel explained what the claim was and it wasn't. It's not a separate trust fund claim on behalf of creditors. That was only significant to establish that Dr. Malhotra is not the same entity as the corporation. My time is up. But
we are certainly interested in the facts in this case. So thank you for your contribution to our review of this today. We're going to take the matter under advisement at this time, and we will issue our decision in due course. Thank you.
Thank you.